All right, call Toby Weaver.
I've already sworn him in. You may proceed.
May it please the court. Mr. Weaver, can you introduce yourself to the court by stating your full name?
Toby Dean Weaver,
And where do you currently reside?
2034 County Road 1115, Cass County, Atlanta, Texas.
And how are you employed?
I'm a truck driver, self-employed.
Okay. Long haul, short haul, how would you describe it?
Long haul over the road.
Okay. Does that require you to be gone from Cass County for extended periods?
Yes, sir, it does.
Typically, how long are you gone before you return?
I'm usually gone 3 to 4 weeks at a time.
Okay. And then you return home and have how much time off?
Couple days, 3 days at the max.
Okay. And then you're back on the road again?
Yes, sir.
Okay. Mr. Weaver, we were before the court January 19th at a hearing for temporary orders. Do you recall that hearing?
Yes, sir, I do.
And Judge Dowd's orders were signed on February 2nd and thereafter entered, correct?
Yes, sir.
During the, in between the time of the hearing and the entry of the orders, Mrs. Weaver retained Mr. Weems to act as her legal counsel, and on January 25th filed an answer to the original petition, correct?
Yes, sir.
After the hearing, did you go back on the road?
Yes, sir, I did.
And what was your intent relative to returning to the marital residence?
Coming home and her leaving the residence and being able to handle my affairs without the hindrance.
Okay. And you're aware, are you not, that Judge Dowd previously ordered that Jennifer Nadine Weaver and her adult son, Brian Bennington, had until February 28th to vacate the premises, correct?
Yes, sir.
Did that happen?
No, sir.
Okay. Before we go into the violations of the court order, I want to back up a bit. During the period that Mrs. Weaver had legal representation, did I, on your behalf, send written discovery to obtain information from Mrs. Weaver?
Yes, sir, you did.
Okay. And did that discovery become due during the course of time that she had an attorney?
Yes, sir.
And was any information or documents provided?
No, sir.
As a result of that, were we required to file a motion to compel with the court?
Yes, sir, we were.
Additionally, in reference to the prior orders of the court, was Mrs. Weaver required to return certain property to your possession?
Yes, sir.
And did she do that?
No, sir.
Was she also required and enjoined from certain conduct?
Yes, sir.
And was she guilty of one or numerous violations of the court order relative to the temporary injunction?
Numerous.
And all of those are outlined in the motion for enforcement, correct?
Yes, sir.
As a result of her violation of the court order, did you file a motion for enforcement?
Yes, sir.
And were efforts made to set both the motion to compel and the motion for enforcement during the period of time that Mrs. Weaver was represented by counsel?
Yes, sir.
Okay. And were we able to identify a potential date where the court might hear those matters?
Yes, sir.
And as a result of that, did you alter your schedule to make sure you could be back in Cass County for that hearing?
Yes, sir, I did.
Prior to that hearing, did something happen that prevented the hearing from going forward?
Yes, sir, it happened.
And what was your understanding of what happened?
My understanding was that her lawyer had retired or taken medical leave.
Okay. So at the time he took leave, discovery responses were past due and a motion to compel had been filed, correct?
Yes, sir.
And a motion for enforcement had been filed relative to Mrs. Weaver's violations of the court order.
Yes, sir.
Okay. Mr. Weaver, in front of you, I have documents that have previously been provided to both the court and Mrs. Weaver that are identified as petitioners exhibit 1 through 9. You and I went over those this morning, correct?
Yes, sir.
Are you able to identify all of these documents and attest to the court that they are true and correct as to what is depicted therein?
Yes, sir.
And do you feel they would assist you in your testimony and the court in testifying to some matters here today?
Yes, sir, I do.
Your Honor, I'd move to enter petitioners exhibit 1 through 9.
Ms. Weaver, do you have any objection to the court receiving those exhibits?
I don't know what exhibits they are. I haven't received anything.
Okay, well, I will allow Mr. Glass to identify each one and then ask you if you have any objections. Go
Your
ahead,
Honor,
Mr. Glass.
Your Honor, for purposes of the record, these were emailed to the email address that I have for Mrs. Weaver. It's also an email address that she had communicated with me prior to legal representation, and all of these were forwarded to her on Friday so that she would have them in advance of the hearing. Your Honor, petitioner's exhibit number 1 and 2 are copies of com checks that were negotiated by Mrs. Weaver's son, Brian Vindictive. Exhibit number 3 is a Capital One Visa card that was forwarded to the marital residence. Exhibit 4 is a document of deferred payment agreement relative to payday loans that were taken out. Exhibit 5 is a copy of the March 31st, 2021 Red River Federal Credit Union statement. Petitioner's exhibit number 6 is a copy of a GoFundMe account that was set up by Brian Bennington. Exhibit number 7 was a notice that was sent to Bronco Pawn on December the 29th. And exhibit number 8 is a copy of a discovery subpoena that was served on Bronco Pawn. And exhibit number 9 is a text communication between Mr. Weaver and one of the owners of Bronco Pawn.
All right. Ms. Weaver, any objection to the court receiving those documents?
Well, I wish I knew what it was, so I don't know if I should object or not. I don't.
He just described each one.
I understand that, but I have an issue because his client is the one that set up the comm data, and his client's also the one that told me that in the Red River savings account was supposedly for marital support, and he told me to go ahead and get that. So I'm assuming that's what that's about. I don't know.
Okay. I'm going to admit exhibits 1 through 9. May proceed.
Mr. Weaver, relative to exhibits number 1 and number 2, can you describe for the court what these documents represent?
These documents are checks that are served out of my business account. This is how I'm paid through ComCheck. And when you authorize a check, it allows you to withdraw cash from trucking fuel distributors across the country.
And for the court's benefit, Mr. Weaver, if you would, describe how you get paid for your trucking.
I deliver the load. They pay me through ComData, a company called ComData, and they literally take all my pay, and then they either put it on this ComData check, like a savings account through ComData, or now it's direct deposited into a bank account.
Okay. Relative to exhibit number 1, down at the bottom, it notes a process date of February 1 of 2021, correct?
Yes, sir.
And this would have been after we came to court on January 19th for the hearing on temporary orders, correct?
Yes, sir.
And what, if anything, of significance do you note relative to this ComData check that's marked as Petitioner's Exhibit 1?
One, it has my driver's license number on it and Brian Bennington's signature.
Okay. After we came to court and you asked the court for relief relative to Mrs. Weaver and her adult son, who y'all had been supporting, did you give Mr. Bennington or Mrs. Weaver authority to go to ComData and take funds out?
No, sir, I did not.
And Petitioner's Exhibit 1 is a check for $200, correct?
Yes, sir.
If you would go to Exhibit number 2. Is this a similar check where Brian Bennington has taken money out of your ComData account?
Yes, sir.
Let me ask you this, Mr. Weaver. Is Brian Bennington sophisticated enough, at least based on your experience, to know how to contact ComData and take money out of your account?
No, sir, I do not believe so.
Okay. Would that take knowledge of how that process works, who to contact, and what information to provide?
Yes, sir, it would.
Other than yourself, who else would have that type information?
Jennifer Nadine Weaver.
Okay.
Mr. Glass, let me stop you just a moment.
Yes, John.
You have, as I understand it, two separate motions before the court. You have a motion to compel answers to discovery, and you also have a motion for contempt. Is that correct? Or a motion for enforcement?
Correct, Your Honor.
Is one of the remedies you're seeking in that motion for contempt incarceration of the respondent?
It is, Your Honor.
Okay. And I'm going to have to go into the question of whether or not she remains able to afford counsel, because I cannot proceed with that. If she's not able, I'll need to appoint her a lawyer. Ms. Weaver, you did have counsel for which you had, I assume that you had retained Mr. Weems at some point in time back in, I believe it was February or March. Is that correct?
It was January after the hearing. Yes, sir.
And I assume also that you're aware that he's recently been allowed by the court to withdraw as your counsel on his own motion, stating that he is, for health reasons, retiring from the practice of law. Were you aware of that?
Yes, sir.
Okay.
Could I address something about the contempt of not leaving the house? It was under his.
No, we're not going to get into that right
Okay.
now. I'm trying to find out if I should appoint you an attorney. What's your current financial situation?
I don't have any finances.
Do you have any income of any type?
Just my son's working.
Your son's working. Do you have any income
No, sir.
yourself? How
No,
are
sir.
you?
I'm still pending disability.
How were you able to hire Mr. Weems in the first place?
Well, with help from friends and payment arrangement.
Okay. Are you currently financially able to hire an attorney?
I am not.
Do you have any income source at this time of any type, or anyone that can help you hire an attorney?
I do not.
Do you understand that one of the types of relief that Mr. Glass is asking for, and that the court could, if the court finds you violated the court's orders, grant, is to place you in jail for a period up to 6 months? Do you understand that?
I do now. I didn't understand it. I don't, like I said, I don't know anything about how this works. I was just going under the advice of my attorney.
Okay.
Your Honor, the remedies that we seek through enforcement is outlined in the motion for enforcement that was filed while she had legal counsel.
I understand, but I think the fact that she had counsel at the time is not going to help the court very much when it comes to the fact that she doesn't currently have counsel, because the question is whether or not she is presently indigent, unable to afford counsel, if incarceration is sought as a remedy, which apparently it is. Well, not apparently, it is, because you've told the court that.
And Your Honor, that is in part why we produced exhibit number 6, showing that her and her son have set up a GoFundMe page,
Right.
to help her with her financial or her legal endeavors.
Okay.
That GoFundMe is no longer up. It was taken down very early on in this. and the $120 was given back to the donors.
Well, I'm going to go ahead and appoint her a lawyer, Mr. Glass, for the contempt action. I'm going to appoint Clint Allen as her attorney. And I'll set off the enforcement action until such time as Mr. Allen can be notified and come up to speed on the case. Now, as far as the motion to compel, are you also asking for incarceration as a remedy in connection with that motion?
No, Your Honor.
Okay, then I'll proceed with a motion to compel today then. So,
Your Honor, relative to the enforcement, my client has and will continue to incur harm due to her refusal to leave the residence. We have no other remedy from the court than to ask for a writ of attachment to physically remove her. Otherwise, he's displaced indefinitely. She was required to vacate the home under this court's order over a month ago, and her son are still living there.
Your Honor, can I speak?
yes.
If you'll give me to the end of the week, I'll be happy to leave. I was under the advice of my attorney at the time, but I will be happy to leave the home if you'll just give me to the end of the week to get my things.
You talking about this Friday?
Yes, sir.
All right. Well, I'll conditionally grant the writ of attachment, Mr. Glass. If she's not out by 5 o'clock this Friday, then I will sign the writ of attachment or order for the writ.
And Your Honor, can the court reiterate its prior orders that she can't take anything other than her personal belongings out of the home? I don't want the home pillaged when Mr. Weaver gets back in it.
Absolutely. Ms. Weaver, you need to, since you're now representing yourself, at least until you have a chance to meet with Mr. Allen, you need to go back over that court order that I signed some time ago. Do you still have a copy of it?
I do. I'm not going to pillage the home. I'm just going to remove my personal items.
You need to read over it and make sure you're in compliance, because your failure to comply is punishable by contempt and confinement in jail.
Yes, sir.
You understand?
Yes, sir.
Okay. Do you know Mr. Allen where his office is?
I do not, but I'll find out.
It's in Atlanta,
Okay.
downtown.
Your Honor,
Yes.
if I may, as indicated in Mr. Weaver's testimony, this is the second time he's had to leave his job, come in during a pending bankruptcy to try to get Mrs. Weaver's cooperation. I was able to confer with him while you were speaking with Mrs. Weaver, and so that we don't further prolong this, he would like to go forward with the enforcement with the understanding that we cannot seek incarceration at this point.
Okay. Well, that's acceptable to the court.
Okay.
I can go forward with it as long as there's no incarceration being sought. So you may proceed with that.
Thank you, Your Honor. Mr. Weaver, relative to petitioner's exhibit number 2, this is another $140 check that was negotiated by Mr. Bennington, correct?
Yes, sir.
Without your consent?
Yes, sir.
And again, the same process would have had to have been employed for him to take money out of your account.
Yes, sir.
Were you able to discover additional efforts to liquidate money from the COM data that is not represented in petitioner's exhibits 1 and 2?
Yes, sir. There was another $100 check that was never cashed, so they returned it after 60 days.
Okay. Meaning it was negotiated, or meaning it was written, but whoever received it didn't cash it?
It was authorized to be cashed out, but they never took it anywhere to cash it.
Do you know who authorized that?
It was authorized through Jennifer Weaver or Brian Vindictive
Okay.
by telephone.
Relative to exhibit number 3, did you recently order a Credit One credit card?
No, sir, I did not.
Okay. Did you receive this in the mail?
Yes, sir, I did.
And who, it notes in the top left-hand corner that one card was ordered, correct?
Yes, sir.
And it was sent to the address that Mrs. Weaver has occupied and refused to vacate, correct?
Yes, sir.
And it was actually a credit card that was sent to you.
Yes, sir, it was.
Did you authorize any application to get a credit card in your name either before or after we went to court on the hearing on temporary orders?
No, sir, I have not.
Relative to exhibit number 4, these are payday loans, a delinquency notice that was sent to you, correct?
Yes, sir.
Have you taken out any payday loans?
No, sir, I have not.
Did you make inquiry to determine if this was one loan or multiple loans?
Yes, sir, I did. And it turned out to be multiple loans.
Okay. And again, it's to your name at your address, correct?
Yes, sir.
Did you authorize or consent to any of these loans being taken out?
No, sir, I have not.
Did you also make any discovery that we didn't talk about at the last hearing relative to Western Union transactions?
Yes, sir, I have.
Okay. And what, if any, discovery did you make relative to Western Union transactions?
I found that over the period of 2019, there was $11,885.81 sent Western Union transaction to some order.
Okay. And this is over and above all the monies that we talked about at the last hearing that were liquidated from accounts without your knowledge or consent?
Yes, sir, it was.
Okay. Relative to exhibit number 5, can you tell the court the significance of this Red River Federal Credit Union statement?
This statement shows the amount that is paid by my trustee, bankruptcy trustee, to the account attached to the loan.
Okay. In the upper right-hand corner, this shows to be a statement ending March 31st of 2021, correct?
Yes, sir.
And the name on the account is your name only, correct?
Yes, sir.
Okay. Will you explain to the court how Red River works relative to the checking and savings accounts?
Red River works as a savings account is through the primary, the checking account. If you have someone signed on with you or as a signature can use the checking account. And Red River had me lock down the checking side of it, but I had to leave the savings side open for the bankruptcy.
Okay. So as part of your bankruptcy, you had to leave the savings account open.
Yes, sir.
Is Mrs. Weaver's name attached to that savings account?
No, sir, it's not.
Okay. Did you become aware relative to money being taken out of that savings account by Mrs. Weaver?
Yes, sir, I was.
How did you become aware?
We became aware of it when the bankruptcy lawyer and the bankruptcy trustee was asking for the accountability of the payment that I do not have any way of, or not supposed to use it because that is strictly deposited for bankruptcy purposes.
Okay. So meaning money goes into this account and then the trustee uses that money to satisfy obligations in your bankruptcy.
Yes, sir.
Mrs. Weaver took money out of that account. And so the bankruptcy trustee comes to you and says, where's the money?
Yes, sir.
Okay. Would you ask for orders of the court that Mrs. Weaver do anything that she needs to do to contact Red River and remove her name from that account so that that doesn't happen in the future?
Yes, sir.
Okay. Relative to petitioner's exhibit number 6, did you become aware of a GoFundMe account set up for Mrs. Weaver?
Yes, I did.
Okay. And is exhibit 6 copies that were taken online of this GoFundMe account?
Yes, sir.
Okay. It notes on page 1 that it was set up by Brian Bennington, correct?
Yes, sir.
And that's Mrs. Weaver's adult son who lives in the home with her.
Yes, sir.
It notes that her husband completely abandoned her. Is that true?
No, sir.
It notes that her husband took everything out of every account. Is that true?
No, sir.
It notes that her husband left her with no vehicle. Is that true?
No, sir.
On the second page, it notes in the upper left-hand quarter that you're supporting helping a mother in desperate need. Your donation will benefit Brian Bennington. Do you see that?
Yes, sir, I do.
And then on page 1, it notes that at this point in time, there was an anonymous donor and a G Heart Care giver for a total of $120.
Yes, sir.
Do you feel that this was another effort to defraud people of money?
Yes, sir, I do.
Relative to the mail that has been forwarded to the marital residence since the last hearing, how many pieces of mail have you actually received?
Since January, I've only received 4 pieces of mail.
Is that unusual?
Yes, it is. Usually every mail delivery, I have 5 to 6 pieces in there daily.
Okay. And you're aware, are you not, that under the prior orders of the court, parties couldn't tamper with stuff, divert mail, do those sorts of things?
Yes, sir, I was.
Do you feel that that's happened dozens of times since we were in court last time?
Yes, sir, I do.
Have there been instances where you have found that your email account has either been hacked or email has been sent out from someone purporting to be you to other people?
Yes, sir, I have.
Has that happened on one or numerous occasions?
On numerous occasions.
Okay. Have you been able to stop that?
Yes, sir, I have.
Who would have known your account numbers such that they could have got onto your account and sent out fraudulent email?
Jennifer Weaver.
Anybody else?
Probably her son, Brian.
Okay. With her assistance?
Yes, sir.
Have there been occasions since the last hearing where you have been told things about hard drives on computers by Mrs. Weaver?
Yes, sir, there has.
And what has she told you?
She told me that they were contained child pornography, underage pornography, and that if I wanted them back, I'd have to go to Atlanta Police Department to receive them.
Okay. And did you in fact go to Atlanta Police Department?
Yes, sir, I did. 30 minutes later.
Okay. And did they have copies of your hard drives?
No, sir, they did not.
Okay. If you will, for the court's benefit, describe these hard drives and what might be on them.
These hard drives are roughly half the size of this sheet of paper. They're a terabyte each. They have TM manuals on them when I work for the government, which is all the tech manuals. They also have my pictures that I took over there while I was overseas, and they have music on them. Downloadable music.
Okay. Would you ask the court to enter orders that these hard drives be returned to your care and custody?
Yes, sir, I would.
You heard, did you not, Mr. Weaver, my discussions with Judge Dowd earlier relative to the pawn shop?
Yes, sir, I did.
You're aware, are you not, of efforts that were undertaken by me to issue a discovery subpoena to obtain records?
Yes, sir.
Okay. And did the pawn shop give us the records that we requested?
No, sir, not all of them.
Okay. Relative to the records that they did provide, were you able to discover information relative to property that was pawned by Mr. Bennington and Mrs. Weaver?
Yes, sir, I was.
Did you also have subsequent discussions with the pawn shop owner relative to her interactions with Mr. Bennington and Mrs. Weaver?
Yes, sir, I did.
And did Mrs. Runnels make any comments to you relative to whether this was only Brian Bennington or it was he and Mrs. Weaver?
Yes, she did.
What did she tell you?
She told me that on numerous occasions and most of the time, both of them were there.
Okay. And that would include the pawning of several guns.
Yes, sir.
Do you recall what Mrs. Weaver testified to under oath at the last hearing as to her knowledge of any guns being pawned?
Yes, sir, I do.
And what did she tell Judge Dowd at the last hearing?
She told Judge Dowd that she specifically had no knowledge of any guns.
Okay. And were you able to determine whether or not the pawn shop still had any of your guns after we were in court last time?
Yes, sir, I did.
Okay. And to your knowledge, were any efforts undertaken by Mrs. Weaver to get those guns back to you?
No, sir.
And you're aware that the prior order specifically told Mrs. Weaver to secure and return any personal property items that had been removed from the home, to include all guns and weapons?
Yes, sir.
Were you able to eventually talk with the pawn shop and pin down one gun that they had in their custody last month?
Yes, sir, I was.
And what gun was that?
That was the Model 58 Smith & Wesson 38 Special.
Now, was that a gun that you bought during your marriage to Mrs. Weaver?
No, sir, it was not.
Okay. That would have been your separate property.
Yes, sir.
Okay. And did the pawn shop turn over that gun to you?
No, sir, they did not.
What, if anything, were you told relative to how you could get that gun back?
I was told that they had found it and that I could buy it back for what they had in it.
And what was that?
I was under the impression that it was $80 pawn, and they proceeded to try to sell it back to me for $300.
The vehicle that Judge Dowd temporarily awarded to Mrs. Weaver, and let me ask you this. To your knowledge, does Mrs. Weaver currently have a valid Texas driver's license?
No, sir, she does not.
Okay. The truck that was awarded to her, is it your name's on that vehicle?
Yes, sir.
Is the vehicle insured?
Yes, sir, it is.
Okay. In light of the fact that if she operates it, she would be operating a motor vehicle in the state of Texas without a license, would you ask the court to allow you to remove that from your insurance in order that she provide coverage?
Yes, sir.
Do you feel that those steps would be necessary to protect you in light of the fact that the court temporarily awarded the vehicle to her if it's wrecked or if someone's harmed relative to that vehicle?
Yes, sir.
You don't want your name associated with it. Would
No,
that be
sir.
fair?
No, sir, I do not.
Is her son also, are you paying for his insurance on that vehicle?
Yes, sir, I am.
Okay. You understand that the court's orders, you have to seek permission of the court before you do these things.
Yes, sir, I do.
And would you ask permission of the court to remove both Mrs. Weaver and Mr. Bennington from insurance on that vehicle in order that if she gets a valid driver's license and if she's going to drive it, that she be ordered to provide insurance?
Yes, sir.
Mr. Weaver, since we went to court the last time, would it be safe to say there's been numerous occasions when you've had to notify me of things that weren't being done pursuant to Judge Dowd's orders?
Yes, sir.
In addition to the relief you're asking today, have you gone to the Cass County Sheriff's Department?
Yes, sir, I have numerous times.
Okay. Have they been able to assist you with anything?
Not very much.
Okay. Did they indicate that they would look into any particular aspect that we've talked about today?
Yes, they did.
And what was that?
The illegal use of the comm data and my guns and the hard drives.
Okay. Have you been told that they will take care of all of that, or this is civil matters for Judge Dowd to deal with?
They have, on all three occasions, said this is a civil matter.
Okay. Have you gone to the Cass County District Attorney's Office trying to get assistance?
Yes.
Okay. And or have they indicated they will pursue things, or have they indicated this is a civil matter to be dealt with in the divorce?
They have indicated that this is a civil matter to be dealt with in the divorce.
Mr. Weaver, how do you feel right now knowing that we went to court and Judge Dowd issued all of these orders and Mrs. Weaver's not complied with anything?
A little upset.
Okay. Do you feel helpless?
Yes, sir, I do.
Do you feel that the sheriff's department or the DA's office is going to jump in and stop this?
No, sir, I haven't felt that.
Okay. Is it difficult to be a long-haul truck driver and take care of business so that you can pay your obligations in bankruptcy and deal with all of this on top of that?
Yes, sir, it is.
Mr. Weaver, what are you asking of Judge Dowd today?
I'm asking again that the court step in and help me rectify this situation to where I can proceed with my other obligations in the bankruptcy and be able to have my funds and take care of my business.
Basically the same thing we asked back in January.
Yes, sir.
Do you have any level of confidence that Mrs. Weaver is going to do anything she says she's going to do?
No, sir, I do not.
Okay. You see any reason why it's going to take her until the end of the week to get out of the house?
Yes, sir, I do, because she hasn't planned in the last 2 months to even move.
Okay. So despite the fact that Judge Dowd said on January 19th, I'm going to give you until February 28th to vacate the house, it's your understanding she's made no efforts to plan to vacate?
No, sir.
Okay. Would you ask that she be given 48 hours to get out of the house?
Yes, sir.
And take her son with her?
Yes, sir.
And if not, that Wednesday at 5 o'clock, if she's not out, that the court issue a writ of attachment and have the sheriff's department physically remove both Mrs. Weaver and Mr. Bennington from the house?
Yes, sir.
Okay. Do you feel that if she's given another week or another month that you could incur additional damage?
Yes, sir, I do.
Are you asking that through the motion for enforcement by contempt and the motion to compel that you receive an award of your attorney's fees and costs that you've incurred?
Yes, sir.
Are you asking that she be ordered to turn over the hard drive?
Yes, sir.
Are you asking that she be ordered to insure the vehicle that's in her temporary care and custody if she's going to use it?
Yes, sir.
Would you ask that she leave all property in the marital home other than her personal hygiene items?
Yes, sir.
Are you asking that the order dictate that she is to do anything she needs to do to make sure that her name is removed from any accounts that you have access to, such that she cannot continue to deplete funds from any account?
Yes, sir, I do.
Do you have concern that despite whatever is ordered today, we're going to be back before the court seeking other relief?
Yes, sir, I do.
Okay. Relative to the items at the pawn shop, were you able to go through the documents that were provided by Mrs. Reynolds?
Yes, sir, I was.
And we were able to work our way through these documents, correct?
Yes, sir.
And there are documents listed such as power washer, lawn and garden equipment, Troy Built Professional Series, impact wrenches, Craftsman drive sets. All those items, were they yours?
Yes, sir, they were.
Were some of those items separate property, or was all of that bought during the marriage?
That was separate property that I had prior to marriage.
Okay. And you're aware that those items were pawned, correct?
Yes, sir.
There were also items such as a weed eater, a Cub Cadet, looks like a straight shaft. Was that an item that you owned prior to the marriage or bought during the marriage?
Bought during the marriage.
You're aware that it was pawned as well, correct?
Yes, sir.
Air compressors, air hoses, did you own those prior to the marriage or purchased during?
Purchased during.
Okay. You're aware those were also pawned, correct?
Yes, sir.
Were those pawned without your knowledge and consent?
Yes, sir, they were.
Did you benefit in any manner from any of the funds received from the pawning of those items that were bought during the marriage?
No, sir, I did not.
Makita drills, Tundra inverter, were those your items of separate property or community?
The Tundra was mine and the Makita was his, was Brian Bennington's.
And did you also become aware of numerous firearms that were pawned?
Yes, sir, I did.
Okay. Were you able to come up with a listing of the guns that were community property, meaning purchased during the marriage versus separate property?
Yes, sir, I was able.
Okay. And can you tell the court how many guns that you owned that were taken that were your separate property?
There was 4 of them.
Okay. Were you able to locate any of those as being pawned at Bronco Pawn and Gun?
Yes, sir. I was able to locate that they were all were pawned at one time.
Okay. Meaning that at one time they were all pawned and then redeemed.
Yes, sir.
Okay. And then what is the current disposition of those guns?
Unknown, except for one of them.
And was that the one you testified to earlier, the
Yes, sir.
Smith & Wesson?
Yes, sir, it was.
Okay. Were you, and marked as exhibit number 7, Mr. Weaver, you received a copy of this letter that I sent to Bronco Pawn, correct?
Yes, sir, I did.
And attached to the letter is a green card noting that Bronco Pawn received it on December 31st of 2020, correct?
Yes, sir, there.
At that point in time, or did you become aware that Bronco Pawn had numerous guns in its possession that were yours?
Yes, sir, I did.
Both community and separate property.
Yes, sir.
And as you sit here today, the only gun that's left is a Smith & Wesson that they want to charge you retail price for.
Yes, sir.
Did you become aware of any efforts undertaken by Mrs. Weaver to go to Bronco Pawn and get any of these guns back after we came to court?
No, sir.
Meaning to preserve your separate property or your community property interest in any of these guns?
No, sir.
Mr. Weaver, do you again feel that this type of conduct is going to continue the longer Mrs. Weaver is left in the marital home?
Yes, sir, I do.
You understand and appreciate, do you not, that when she's in the marital home, she's going to have access not only to her property, not only to y'all's property, but also to your separate property?
Yes, sir, I do.
Again, would you ask the court to step in and to protect both your interest in community property as well as your separate property to the greatest extent possible?
Yes, sir, I do.
And are you asking the court to monetarily sanction Mrs. Weaver for her conduct, to include attorney's fees and any sanctions from a monetary standpoint that the court might impose?
Yes, sir, I do.
Relative to the truck, if she doesn't have a license and she can't insure it, would you ask that the truck be put back in your care and custody so you can safeguard it?
Yes, sir, I would.
Your Honor, I'll pass the witness at this time.
All right, Ms. Weaver, questions?
No, sir. No questions.
All right. Mr. Glass, call your next witness.
Your Honor, I received a note from a paralegal that says Gina Runnels is in the small conference room. She wants you in front of her while the documents are sorted. And I asked my paralegal if she would bring me the documents, and apparently Mrs. Runnels is refusing to turn over the documents. I have her in a small conference room, Your Honor. I would ask to bring her before the court, and I would ask the court to order her to turn over the documents to me. And then if the court could give me 10 minutes to go through the documents, I would be ready to question her at that point.
All right, you can bring her in the room.
Thank you, Your Honor. Toby, if you don't mind moving your stuff, I'm gonna put it in that chair down there. That's right. You can have a seat right there. We have Judge Dowd on the hearing with us, and Mrs. Walston indicated that you were here, but that you wanted me in front of you to turn over the documents.
Yes, sir. I think I have a privacy.
You can speak to Judge Dowd if you don't mind.
I have a privacy, and I don't know how to phrase this, but as a pawnbroker, I am under limitations of what I can turn over unless it is a criminal investigation.
What documents do you have, ma'am, that are responsive to the subpoena that you received?
Well, I don't have anything other than what I've already given Mr. Glass. He subpoenaed the documents that I had before, and I really don't think that the ones that I gave him, I should have given him, because the Texas pawnbrokers regulations, well, it's the Texas Administrative Code says that I cannot give any documents or privacy. My customers are protected by the Privacy Act unless it is a criminal investigation. And the Texas Administrative Code says that, and so does the Privacy of Consumer Financial Information, the federal regulation. Because I am a loaning institute.
Okay, well, you've complied with this subpoena as far as you know by turning over any documents to him that you have responsive to the subpoena. Is that correct?
That's correct. I supplied everything that I had that he asked for on the first subpoena.
Okay, all right. Mr.
Your Honor,
Glass?
may I take this witness under voir dire if you'll swear in?
All right. Ma'am, will you raise your hand and be sworn, please? And do you swear or affirm the testimony you're about to give to the court will be the truth, the whole truth, and nothing but the truth shall be God?
Yes, sir.
You may lower your hand. You may proceed, counsel.
May it please the court. Mrs. Reynolds, you referenced you had previously supplied documents, correct?
Correct.
You're aware that the discovery subpoena sent to you had 5 line items? And I've got a copy if that would help you.
I've got it too. Which one? What are you talking about?
That was the subpoena that was sent to you that requested you comply by March the 3rd.
Okay, that was the first one.
The first one, yes, ma'am.
Okay.
If you'll turn to Exhibit A, the Ducis Tecum,
Okay.
that has 5 line items, correct?
Yes, sir.
And your trial subpoena has 12 line items, correct?
Should I have brought my lawyer?
With my understanding, you've talked to 2 different lawyers, so I don't know which one you're talking about.
Well, either one.
You could have brought both of them.
Okay.
Okay. You would agree with me that the discovery subpoena had 5 line items and the trial subpoena has 12 line items?
Yes, sir.
Correct?
Yes, sir.
You would agree with me that in response to the discovery subpoena, you redacted documents that you sent to me?
Explain.
You whited out. You took
Yes, sir.
information out of them.
Yes, sir. That was to cover myself as far as the administrative code, because it specifically says the victims or the person's private information.
Okay. And you didn't provide me photo identifications as requested in the discovery subpoena that's marked as exhibit number 8, did you?
Explain photo.
A driver, I assume people have to come in and show you a driver's license to make sure that they're not pawning stolen equipment.
Yes, sir, but to me, that's a privacy thing.
Okay, I'm not asking you your legal opinion. I'm asking you what I asked for that you didn't provide me.
I
Okay,
could not provide you
I'm
that.
not asking you what you can or can't. I'm just saying you did not provide me a photo identification.
No, sir, I did not.
You didn't provide me criminal history reports, did you?
I don't have any of that.
Okay. You received a copy of a letter from me on December the 31st advising you that Mrs. Weaver and Mr. Bennington were pawning my client's separate property, correct?
I had no way of knowing whose property that was.
I'm not asking you
I
what
received
you
a
know.
letter from you. Yes,
Okay.
sir.
But in response to my ducis tecum, where I asked you for a copy of all written and electronic correspondence received by you within the last 5 years in reference to any items of personal property pawned by either Jennifer Weaver or Brian Bennington, you didn't produce a copy of my letter.
I could not do that because I can't do that for my clients because of the administrative code. I can't do that unless it's a criminal investigation. That's what this says. I don't want to lose my pawn license.
Well, as a matter of fact, I asked you for a copy of your pawn license. You didn't even provide me that, did
I
you?
did not. You're right. I
Okay.
neglected to do that.
And then in your trial subpoena, in addition to the information I previously requested, I asked for any photographs, videos, or digital images of the products. Do you not take photos of guns that come in?
No, sir.
Okay. Do you not take down the identification numbers, serial numbers
You
for
got that.
guns?
You got that.
Okay. Did you have any internal notes, letters, or communications relative to this? Okay. Do you have to provide any written or electronic documents to the sheriff's department or? Okay.
Ms. Weaver knows that.
Okay. And you didn't provide any of that to me.
I can't do that
I'm not
because,
asking you what the law is. I'm asking you what
no,
you
I
gave
did
me.
not do that.
Okay. And you didn't give me any other communications you would have sent out relative to any personal property pawned by Jennifer Weaver or Brian Bennington, did you?
There was none.
Okay. Did you, and now I'm switching gears to the trial subpoena. Did you provide me documents showing what inventory you would have had of property pawned by Jennifer Weaver or Brian Bennington as of January 1 of this year?
No, I don't guess I did. I don't know what you're asking for.
Okay. Well, what I want to know is once you received notice that you had property that belonged to Mr. Weaver, what property you would have liquidated after that point in time?
I had no way of knowing that property did belong to me.
I'm not asking you what you know. I'm asking you. And did you notice in the letter that I sent you, it said, this correspondence is to put you on notice of same and to request that you hold Mr. Weaver's personal property for safekeeping pending an order related thereto from Judge Dow. Did you see that?
I saw that.
Okay.
But
You would agree with me that after you received this letter, you liquidated property that was pawned by Mr. Bennington at your shop?
yes,
Okay. Your Honor, that's all I have as far as the voir dire. And I have additional questions for the witness. I don't know if she's refusing to answer the questions or provide the documents. Mr. Allen and I had a discussion as to whether or not a pawn shop is exempt from complying with a Texas subpoena when a physician has to produce medical records pursuant to subpoenas and court orders. But if she is aware of those laws and can convince the court, Your Honor, that's obviously a call the court would make.
Well, let's do it this way.
And Your Honor, I can agree that any document she gives me will be held pursuant to a protective order. I'm not going to disseminate it outside this case, and it's going to be used to further the case against Mrs. Weaver and or the case against Bronco Pawn relative to the property.
Okay. Well, this is what I want to do regarding these documents, ma'am. The Texas Rules of Civil Procedure basically provide that you have to produce any documents that are requested unless, and that's a big unless, you file an appropriate motion to, what's called a motion to quash the subpoena or parts of it. You haven't done that. Therefore, everything as far as the court is concerned that he's requested, at least at this point in time, has to be produced. So here's what I'm going to do. I want you to go back through. You've been served with 2 subpoenas. One of them, I think, asked for 5 line items, and one asked for, I think, 12 line items. I'm going to give you some more time to go back through each of those subpoenas, identify any and all documents that you think are responsive to the subpoena. Within 10 days of today, you must do one of 2 things. You must either turn over all of those documents without redaction, without change, without anything else, or you must obtain counsel and have counsel file a motion to quash the subpoena or parts of it and get a hearing whereby I would at that point in time decide whether or not that particular item should be disclosed. Do you understand my instructions?
I think so. Yes, sir.
Okay.
Are these, let me ask this, the documents that you're asking for are strictly ones that are pertaining to Brian Bennington or Jennifer Weaver? Because I have some third-party deals in here that they have nothing to do with this hearing or this case.
Well, the documents ask for specific documents, and whatever is asked for, you have to produce. If there's a question, if it's a question, we'll go ahead and produce it, and then I'll decide if it's relevant or not to this proceeding. Okay.
We're discussing guns, which throws into another, instead of just my pawnbroker's license, it also throws up my ATF, my FFL license, which brings in the ATF. Because these guns were defaulted before any of this started and were sold, am I supposed to provide information on who bought those guns? Because I think that it violates that. See,
I'm not. That's why I'm asking you to make the appropriate objections to whatever is requested, and then at that time I will rule on those objections. I'm not going to rule on all of that today. You just need to produce whatever is asked for, and then I will rule on it at a later time. Okay?
So I need to get a lawyer. That's what you're telling me.
Yes, ma'am. It sure sounds like it, because you're saying you have good legal reasons why you should not have to produce what he's asking for. And you may, I don't know whether you do or not at this point, but that's why the burden is on you under the law to bring those reasons before the court and let the court rule on it. And that's, I would say, unless you have very skilled knowledge of how to do that, then you're going to need the help of an attorney.
Thank you.
Okay. All right.
Your Honor, if I may, in light of a representation that Mrs. Reynolds just made to the court, I would like to further my voir dire on a couple of issues.
Okay, go ahead.
Mrs. Reynolds, you just represented to the court that things were done to these guns, meaning they defaulted before this legal proceeding. I want to show you some documents that you did provide me. If you look at the second page of that document, those defaulted after you received this notice letter, correct?
Correct.
And what guns defaulted at that point in time?
Anderson Arms, AR, the Anderson Arms.
Okay. So after you received notice that you had Mr. Weaver's separate property in your care and custody, that gun defaulted. Is it safe to assume you sold that gun?
Yes, sir.
Okay. I'm going to show you another set of documents here. Is this reference to another firearm?
Yes, sir, to Henry.
Okay. And if you look at the second page, that would have defaulted after you received that notice letter, correct?
Yes, sir, it did.
And did you get rid of that property?
Yes, sir.
I'm going to show you another set of documents here. What are those in reference to?
That's a revolver, Smith & Wesson.
Okay. And did that default after you received your notice letter?
Yes, sir.
Okay. And do you still have that in your care and
No,
custody?
sir, it's not. It's sold. It's on layaway.
Your Honor, I can't remember if the court swore this witness or not.
Yes, sir.
Okay.
It did.
Yes, I
Okay.
did.
Okay. I just wanted to establish, Your Honor, she testified earlier that they defaulted before this legal proceeding, when in fact, at least those weapons defaulted after the legal proceeding and after she received notice that she was in the care and custody of Mr. Weaver's separate property.
All right.
May I say something?
Well, I think I've ruled on what needs to be done about the documents, Mr. Glass, so I'm going to release the witness at this time unless you have other relevant questions to ask.
I don't, Your Honor.
All right, ma'am, you're excused.
Okay.
Right, 10 days from today, would that be delivered to my office on the 10th day or before?
By 5 p.m. On the 10th day from today. I'm not sure what date that is.
Okay, what, now, if I get a lawyer to represent me in my business, to keep from losing my business over a divorce case, what does that mean? He just,
Ma'am, that's what you'll have to ask the attorney.
but as far as you're concerned, I'm trying to make sure that I do what you're telling me to do.
What I'm telling you is pretty simple. I want you to make sure you understand all of the items that he's asking for in the 2 subpoenas. Produce all of those items without qualification or change or redaction, unless by and through your attorney, a proper objection is made to one or all of those items, and the court conducts a ruling on each objection. Okay?
Okay, so if I just want to make sure I'm doing what you're telling me to do. If I go get a lawyer and let him file the objection to what Mr. Glass is asking for.
Correct. Absolutely.
Okay, I just wanted to be clear on that.
That's absolutely correct.
Okay,
Okay.
thank you. Thank you.
You're excused.
Thank you, sir.
Thank you. Your Honor, I call myself as the final witness.
All right, raise your hand and be sworn. Do you swear or affirm the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
You may proceed.
May it please the court? Your Honor, for purposes of the record, my name is David Glass. I'm a partner with Smith Weaver Law Firm. I've been licensed in Texas since 2002, in Arkansas since 2003, admitted to practice before all state courts, also the federal courts in the Eastern District of Texas, Eastern and Western Districts of Arkansas, and the 8th and 5th Circuit Courts of Appeals. I'm an AV-rated attorney by Martindale-Hubbell. My hourly rate's $3.25 an hour. The time expended on the motion to compel and the motion for enforcement at that rate are fair and reasonable for the same or similar services rendered in Cass County, Texas. The fees and expenses incurred by my client were reasonably and necessarily incurred. Relative to the motion for enforcement, I've spent no less than 3.5 hours. Relative to the motion to compel, no less than 1.4 hours. And this is exclusive of any cost or expenses that Mr. Weaver has incurred due to my dealings with Bronco Pawn and Gun, They have been segregated out. A request would be made for attorney's fees against Mrs. Weaver in the amount of $1,592.50 in the addition to any other monetary sanctions the court might award. And I would rest subject to any questions of Mrs. Weaver or the court.
Mrs. Weaver, do you have any questions of this witness?
I just know I can't afford that right now.
Okay. Do you have any questions?
No.
All right. Call your next witness, Mr. Glass.
You're not rest at this time.
Mrs. Weaver, you're representing yourself. You have an opportunity to testify. You're not required to do so. If you do want to testify, you'll need to raise your hand and be subject to cross-examination.
I would like to wait for counsel if I could.
All right. All right, Mr. Glass, I think I know most of what you're asking for in the way of enforcement, but I need you to itemize those matters. First of all, I will grant the request for attorney's fees and costs of court incurred in connection with these motions in the total sum of $1,592. I will order that the respondent, Mrs. Weaver, immediately return the hard drives that were mentioned in the testimony, order that she obtain her own insurance on the vehicle that was temporarily awarded to her, and the petitioner is allowed by the court to drop any insurance he's currently carrying covering that vehicle. She is to, as I stated earlier, vacate the current residence or current property by 5:00 p.m. this Friday. Failing that, the court will issue a writ of attachment for her and any other resident of the premises to be removed by the sheriff. She is to not remove any other personal property other than personal items that she may need for clothing and jewelry and things of that nature, but not remove any other personal property from the home pending further order of the court. Yes.
Could I remove my family photos, my kids' photos and things?
Yes. However, that's probably something that y'all are going to need to share. So.
Well, we don't have children together, so those are just mine.
Yes.
When they were babies and things.
Personal items. Mainly, I don't want any furniture or appliances or larger items. Yeah. As far as, I'm not sure what relief is requested regarding the pawned items. It appears that a lot of those items are no longer in the possession of the pawnbroker. If the remaining gun, I think that's a Smith & Wesson, can be obtained by redeeming it through a pawn ticket, then I would order her to do so. I'm not sure that that's a possibility. I will also, I'm not assessing any type of incarceration for violations of the court's orders, which the court does find that the respondent has violated the court's orders in the manner and methods alleged in the motion for enforcement. And I'll assess a $1,500 criminal fine for those violations. What else is the movement asking for, Mr. Glass?
Your Honor, it may not be this simple, but relative to the Red River bank account, I believe Mr. Weaver's being told by Red River since you already have a loan pulling from that account, we can't make any changes to it. So I don't know if an order that Mrs. Weaver execute any documents necessary to change that account so that she doesn't have access to it would be sufficient for the bank, but that may be the only relief we could request of the court today in that respect.
I will grant it.
I don't have a problem going to the bank and taking my name off the savings account. I will do that.
Okay. Anything else?
And Your Honor, the funds that were taken from that account, will Mrs. Weaver be ordered to return those? It was in the amount of $375 that I assume belonged to the bankruptcy trustee.
That's the trustee account, yes.
Yes, sir.
I would like to say something though. Until I can talk to an attorney, Mr. Weaver was granted me permission to do that under the premise that it was marital support, because on the statement it says MS, and that's what he told me. So until I could talk to an attorney, I would like.
I'm gonna object to Mrs. Weaver attempting to testify now that the evidence is closed.
That's sustained. The money's ordered returned. What's next?
I believe that's it, Your Honor.
Okay. Mrs. Weaver, again, you did, of course, obtain counsel at one point. If there's any possible way financially you need to do so, I will admonish you that the court has made certain orders that it expects to be complied with. Apparently is not being, or has not been complied with in a number of respects. And that can eventually result with proper motion being filed in your incarceration. I do want to clear this up. I was trying to appoint Mr. Allen to represent you in connection with a motion to incarcerate you. He's not appointed. He is not your lawyer at this time because they withdrew their request that you be incarcerated, which did away with the requirement that I appoint you a lawyer. You're still free to hire your own lawyer. And if there comes a point in time when there is a motion before the court for you to be incarcerated for violating the court's orders, and I will again look into the issue of appointing you a lawyer at that time. Do you understand where the court stands on that?
I guess, yes, sir.
Okay. What do you not understand?
Well, I don't know. I have to talk to somebody about this because this is all very confusing to me.
Okay.
Your Honor.
Yes.
Sorry, Judge. I failed to neglected to mention the motion to compel discovery. The hope is to get her discovery responses so that we can get this set for a final hearing with the court. Issue orders relative to her compliance with the discovery request.
Yes, since of course, the discovery went primarily to her attorney, who has now withdrawn effective the end of March. So I'll grant her another 30 days to get answers to those.
How do I obtain that?
You can obtain your file. In fact, you have a right to obtain your file if you've not already done so from Mr. Weems. In the file, there will be all of the interrogatories and other requests for you to answer certain questions that have been asked in writing and perhaps produce certain documents. And if you don't get another lawyer, you're going to have to answer those yourself. Just go through them to the best of your ability and answer them and give a copy of your answer to Mr. Glass.
Okay, and if it's not in the file, who should I request it from?
Well, it'll be in the file.
Okay.
But if it's not, you can get another copy from Mr. Glass. All right. Anything else?
That's all we have, Your Honor.
All right, then. Parties to this case are excused. Court's adjourned.